Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the Great Canadian Maple Syrup Heist and the legal issue that took this all the way to the Supreme Court. Now, if you're not familiar with the story, you're probably thinking, okay, people stole some maple syrup. How big of a deal can that be? $18 million worth of maple syrup. So that's kind of a big number. To understand how this is possible, because you're probably thinking, how? Like, how could you possibly steal 18 million bucks worth of syrup? We need to look a little bit at the maple syrup industry here in Canada. So Quebec produces almost 80% of the world's maple syrup, but they do so in a fashion that limits the supply. Each producer is given a quota for how much syrup they're allowed to produce and sell out on the market, but they're often overproducing because you don't want to end up under your quota. So all of that excess syrup gets stored and put into a reserve. And basically they leave it there and in order to manage prices. Now, if you're thinking, wait a minute, isn't this anti-consumer because the average person at home, they're not getting the full benefits of a competitive market. Prices are going to be artificially high. Well, yeah, it is, but nobody's going to go after Big Maple, not here in Canada. So anyway, this results in these warehouses full of syrup that's just being stored. And this also results in a bit of a black market because if you're one of these producers and you're producing a whole bunch of extra syrup, you might not want to just store it in some reserve forever. You might actually want to get paid for it. So there's this whole sort of black market of people who buy syrup illicitly from these producers and then sell it to other people. And to give some example or some idea of just how much of a thing this is, they are apparently called barrel rollers. They've got a whole term for the people who are involved in this trade. So there is a market for it, because another thing you might be thinking is, how do you fence $18 million worth of syrup? Well, there's already a black market. What happened in terms of this theft is that one of these warehouses, the people or some people around the warehouse got the idea that they could, maybe help themselves. And so they started stealing barrels of syrup out of there and emptying them out and instead replacing or filling the barrels back up with water. And so then they were putting the original barrels back into the stack, and unbeknownst to anybody, they're just full of water instead of syrup. Now, the way this gets discovered is the way lots of crimes get discovered, which is people got lazy. It was a lot of work refilling those barrels back up with water, once they've taken the syrup out. So they said, you know what, nobody's coming by to have a look at this. We don't need to worry. We'll just put the empty barrels back. Well, they came by to do an inspection and an audit and a count, and somebody was climbing up the stack of barrels and one fell over. And that shouldn't happen because these barrels, when they're full of syrup, should be really, really heavy. So that got him poking around, and eventually everything falls apart and a whole lot of people get charged. And again, $18 million worth of syrup. That's a bit of a big deal. So one of these people was convicted, and as part of this, there was an issue of restitution. And that's the issue that ends up going to the Supreme Court. So let's have a look at this case here. And this is, again, Supreme Court of Canada. So we're in the big leagues talking about maple syrup. And this is the case of the Queen and Richard Valliere. I hope I'm pronouncing that correctly. All right, so let's have a look at what they're talking about here. So in 2016, Mr. Valliere was convicted of fraud, trafficking, and theft in respect of maple syrup. Now, this is not drug trafficking. I mean, in Canada, we take our syrup real seriously, but this is, we don't regulate it that strictly. This is trafficking in stolen property. That's what the allegation is there. And not just allegation, because he was convicted. So the stolen maple syrup, which had a market value of over $18 million, passed through the hands of several individuals before it was resold by Mr. Valliere, who collected the income and paid his various accomplices. So he is the barrel roller who is key to this because he's the guy who can turn syrup into money. Kind of an important role, but also kind of a legally perilous role, as we'll see. So, by his own admission, he earned $10 million in income from the resale of the syrup obtained by theft or fraud and made a personal profit of nearly $1 million minus certain transportation costs. Now, I mean, nice work if you can get it, except, oh, right, you know, crime often falls apart in big ways, and in his case, real big ways, as we'll see. So under section 462.37 sub 3 of the criminal code, the trial judge imposed a fine on him in lieu of an order for property that was proceeds of crime. So a fine in lieu. Because the trial judge was of the opinion that he had no choice but to impose a fine equal to the value of the property that was proceeds of crime that had been in the guy's possession or under his control, he ordered him to pay a fine corresponding to the resale value of the maple syrup obtained by theft or fraud, that is, $10 million minus the amount of a restitution order. So let's stop here and have a look at that section, because that section is going to be really important in terms of looking at what we're talking about here. All right, so we start out, and I'm going to start out at 462.37 sub 1 because sub 3 relies on it. So it says subject, and this is order for forfeiture of property, subject to this section and sections, so lists a bunch of sections. If an offender is convicted or discharged under section 730, so a conditional or an absolute discharge of a designated offense, and the court imposing sentence on or discharging the offender on application of the Attorney General, the government, is satisfied on a balance of probabilities. That's a standard of more than 50%, so a 50% plus one sort of test, that any property is proceeds of crime obtained through the commission of the designated offense. The court shall order that the property be forfeited to Her Majesty to be disposed of as the Attorney General directs or otherwise dealt with in accordance with the law. So what does this mean? Well, this is a provision for, it's, forfeiture, but this isn't really a civil forfeiture because this is after the results of a criminal conviction. But if you are a drug dealer and you use it to buy a really big house and a really fancy car and maybe a jet because you're, in the big leagues, well, this section lets them take all of that stuff. So they say, subsection 2, if the evidence does not establish to the satisfaction of the court the property in respect of which an order of forfeiture would otherwise be made under subsection 1 was obtained through the commission of the designated offense of which the offender is convicted or discharged, but the court is satisfied beyond a reasonable doubt that the property is proceeds of crime, the court may make an order of forfeiture under subsection 1 in relation to that property. So there's designated offenses and just other crimes. And in the case of other crimes, they may make an order. And in terms of the designated offenses, they shall make an order. So that's the difference. Shall means must. May means that the court has some discretion as to whether or not they should or should not. And there's some other provisions there in terms of how they should do it. The designated offenses are a criminal organization offense, punishable by 5 or more years of imprisonment. So that's organized crime stuff. An offense under Section 5, 6, or 7 of the Controlled Drugs and Substances Act, or a conspiracy or an attempt to commit, being necessary after the fact in relation to, or any counseling in relation to an offense under those sections, prosecuted by indictment. So Section 5 is, these are trafficking, import, export, as well as production of drugs. So that's what they're talking about here. And similar stuff for the Cannabis Act, so even though marijuana is legalized, it's kind of semi. And an offense under any of sections 279.01 to 279.03, that's human trafficking stuff. So they, these are mandatory forfeitures. The government will take the money. All right. There's also a provision that allows for the offender to establish that any property is not proceeds of crime. I got this house because I inherited it from my grandma. That was not proceeds of crime. Don't take the house. Grandma gave it to me. So there's a whole bunch of other stuff, and I'm just going to skip over here, and we'll go to subsection 3, because that's the one that's really relevant here. So fine instead of a forfeiture. If a court is satisfied that an order of forfeiture under subsection 1 or 2.01 should be made in respect of any property of an offender, but the property or any part of or interest in the property cannot be made subject to an order, the court may, instead of ordering the property or any part of or interest in the property to be forfeited, order the offender to pay a fine in an amount equal to the value of the property or the part of or interest in the property. In particular, a court may order the offender to pay a fine if the property or any part of or interest in the property. So basically what this is about is situations where they would take your stuff, but they can't for reasons, and they give some specific reasons. So first, cannot on the exercise of due diligence be located. So somebody's a drug dealer, they bought themselves a really, really expensive car, $1 million vehicle. And they've been seen driving around in this car. Everybody knows they've got it, but it's hidden somewhere. It's in some garage somewhere. The government's been looking for it. They can't track it down. Well, they can say, well, we can't take the car, but we can fine you the value of the car. So we're going to come after you that way. Has been transferred to a third party. You gave the car away, and that person is sort of an innocent. We don't want to take the car from them. We really want to punish you, the wrongdoer. So that's another provision. Is located outside Canada. If you've been, if let's say you bought a private island out in the wherever, Canada probably can't take that private island because it's not part of Canada. So that would allow them to instead hit you with the fines. D, has been substantially diminished in value or rendered worthless. So you had a mansion, and then when you knew that the government was going to take that mansion that you got through drug dealing, you burned it, and then you contaminated the land. So now even the land is worthless. Well, they just go after you for the value of what the mansion used to cost through this procedure. Or has been commingled with other property that cannot be divided without difficulty. So if it's mixed in somehow, I guess maple syrup is particularly suitable for that sort of thing, but there's all sorts of scenarios where it could be that it's hard to parcel out whose stuff is what. So that's what that allows for. Now, you might be thinking, what happens if you can't pay the fine? Well, they've got specified penalties for that. So if you default in payment of the fine, there's a term of imprisonment if the fine is under $10,000, not exceeding 6 months. And then there's 6 months and not exceeding 12 months if it's $10,000, and it goes all the way up to, if the fine exceeds $1 million, a period of not less than 5 years and not exceeding 10 years. And this is to be served consecutively to any other term of imprisonment imposed. So after you're done whatever sentence the court has directed, now you have to do the fine in terms of this imprisonment system. So it's real harsh. There's also no fine option program. Normally, if you get a fine for, some sort of criminal offense, you can work that off doing community service. Not in this case. So this is a pretty strict set of provisions. And again, it's really designed to essentially go after people's money if they've been somehow enriching themselves through crime, especially things like human trafficking or, drug dealing. Those kinds of things are sort of specifically targeted. All right, so let's have a look here at, come back to what we're talking about. Actually, maybe I'll just jump back real quickly here, just so that I can point out one other thing here that's relevant. So, and that's the other thing I'll point out here is, in terms of the language, is the court may, instead of ordering the property, order the offender to pay a fine, but then the fine amount is just equal to the value of the property or the part of the interest in the property. There's no sort of, they may order the fine or they may not, but then it says just in an amount equal to the value or the part of the interest in the property that was obtained by crime. Because, let's say you bought a half share in a company with crime. Well, they can't give you the entire, or they can't take the entire company, but they could take the amount of it that is yours. So that's going to be a critical issue here, is this bit of language in terms of that may, the may, and then the strict amount distinction. And I'm already kind of giving away some of where this goes, but let's carry on here. All right, just get that up again here. So the trial judge ordered him to pay a fine corresponding to the resale value of the maple syrup obtained by theft or fraud. That is $10 million minus the amount of a restitution order. $10 million fine. So that's a lot of money. I have never seen $10 million, and I'm pretty sure if I'd never spent a penny in my life and you stacked it all together with interest, it wouldn't be $10 million. So, however, the Court of Appeal reduced that amount to the profit made by Mr. Valliere, $1 million, minus the amount of the restitution order. You can already see where this is going, right? And why the Crown was upset. It held that courts have the discretion to impose a fine that reflects the profit made from a criminal activity, provided that this penalty meets the dual objective of deprivation of proceeds and deterrence. Now, so the objectives there, you want to make sure that crime doesn't pay. That's the deprivation of proceeds. We want to take the money away. And deterrence, as in we want to make it clear to the public and to whoever that, even if you get all this fancy stuff through committing crime or committing, these sorts of offenses, we're going to take it. Like there's no benefit for you in this. Now you can already see here that when they're saying that they're holding that the courts have this discretion, it's not actually written into the statute. They're trying to find a discretion that isn't strictly speaking written in there. And so that's what the court is looking at. It was of the view that the fine imposed by the trial judge, was clearly disproportionate to the objectives of the scheme governing this type of fine, and that it created a situation of double recovery in light of the fines imposed on V's accomplices. So the double recovery problem here is that basically you don't want the government taking the proceeds twice. So let's say, if you imagine, the house scenario, and there's two people involved. In one case, they take the house, and so they've already got that. And then in the case of the next co-accused, they say, well, we already took the house, so we're going to hit you with the value of the house. That's the government double dipping. That's the concern that's being raised here. So held, the appeal should be allowed. So this, the court had said that it would be 1 million. The Supreme Court's going to say, nah, we don't think so. So the holding here, and I'm reading from the summary. I'm not going to read the whole case because this would be real long. And it starts getting a little technical. So I'm just going to keep it to the broad summary here. So V must be required to pay a fine equal to the value of the property that was in his possession or under his control. That is $10 million, as the trial judge found. This amount is warranted in light of the scheme for the forfeiture of proceeds of crime, under which a fine must, in principle, be equal to the value of the property of which an offender had possession or control at some point in time. Because a court does not have the discretion to limit the amount of a fine in lieu to the profit made by an offender from their criminal activity, the Court of Appeal assumed a discretion it did not have when it reduced V's fine. So they don't have that power. They can't use that power. They shouldn't have done it. Moreover, V did not prove either at trial or an appeal that there was a risk of double recovery of the $10 million. So that might have been a defense here, except he didn't establish it. And part of why he didn't establish it is that I understand there was an issue as to whether or not on appeal that issue was something that was raised by either of the parties or just something that the court decided to do on its own. So I don't have the appeals decision. I haven't looked at it because, again, this is just a maple syrup case, although big dollar values. So I didn't go digging into that. Now, I think this kind of makes sense. And the reason why I think it makes sense is, let's go back to our drug dealer or our human trafficker. We like the human trafficker even less. If we're talking about somebody at the big, houses and planes and mansions kind of level, you don't want to say, well, listen, you have earned millions and millions and millions of dollars through this, but at the end of the day, you're only holding on to $10 million worth of property. even though you've spent your way through hundreds of millions, you want to still sort of cover that money that they spent too, right? The stuff that the proceeds of crime that they've already enjoyed. So that's, I think, what this decision captures is those, the money in this case that was dispersed to other co-accused, but in many cases would be stuff that you've already spent. And I think that's kind of a relevant consideration here. So a fine in lieu differs from the sentence imposed for the commission of a designated offense in that its purpose is to replace the proceeds of crime rather than to punish the offender. It is therefore in the nature of a forfeiture order. The imposition of a fine in lieu may be considered where forfeiture of the property that is proceeds of a crime has become impracticable. In such a case, the court may, instead of ordering the forfeiture of the property, order the offender to pay a fine equal to the value of the property as provided for in the section we just looked at. So that's really what they're talking about there. They say the use of the word may indicates Parliament intended courts to have some discretion, but this discretion does not allow them to limit the amount of the fine to the profit made from a criminal activity. The discretion applies only to the decision whether or not to impose a fine and to the determination of the value of the property. Now, I want you to think about this in terms of practical implications, because let's say, like in this case, the trial court said, you know what, I'm going to hit you with the 10 million bucks. And it was the appellate court that said, we're going to limit this. But let's imagine the trial court was the one that had the problem with the $10 million number. Well, how might they get around this when they have this problem of they think the appropriate number is $1 million and that an inappropriate number is $10 million that the legislation is requiring them to impose, unless they decide not to impose it at all. And so what I think you might see as a result of this decision is cases where the court says, listen, I would have imposed a $1 million fine in lieu, but I'm not going to impose a $10 million one, so I'm not going to impose anything at all. This could be an unwanted side effect of this particular decision. We'll have to see what happens down the road, but I think that there is a possibility that that's how courts will deal with it. So they note that the wording of the section is categorical with respect to the amount of the fine. It is equal to the value of the property that is proceeds of crime. So as I mentioned, there's no wiggle room there. There's nothing that allows them to say up to or anything like that. And they say, through the severity of the proceeds of crime provisions, Parliament is sending a clear message that crime does not pay and is thus attempting to discourage individuals from organizing themselves and committing profit-driven crimes. Parliament's decision that the fine must correspond to the value of the property is therefore deliberately harsh. All right, that's strong language. They're not messing around here on this one. So they say, at the step of determining the value of the property, the Crown's burden is only to show that the offender had possession or control of property that is proceeds of crime and to establish the value of that property. The determination of the property's value must be based on the evidence and not on a purely hypothetical calculation. So they have to actually bring some numbers to say, here's what this stuff is worth. They can't just kind of guesstimate it or anything like that. But you'll see that the burden here is not all that hard. Is it proceeds of crime? Did the offender have possession or control of it? And what was it worth? And if you can do all of that, then you can get this situation of a fine, potentially at least. An offender's ability to pay must not be considered in determining the amount of a fine in lieu, any more than in deciding whether or not to impose such a fine. So, doesn't matter that he doesn't have $1 million or he doesn't have $10 million, you're still going to impose it, because it turns out Parliament put in a little way for you to pay it if you don't have the money, and that is lots of sitting in jail. Lots and lots of sitting in jail. So in situations involving co-accused who had possession or control of the same property that constitutes proceeds of crime, courts may divide the value of the property between the co-accused if there is a risk of double recovery, if apportionment is requested by the offender, and if the evidence allows this determination to be made. The onus is on the offender to make the request and to satisfy the court that it is appropriate to apportion the value of the property between co-accused. Now you might be saying, oh man, this guy's lawyer screwed up. Well, this case didn't exist before. And so this gets into an interesting legal fiction of this. And legal fictions are basically things we imagine for the law to work. And one of those is that the law always exists and that kind of the Supreme Court and other courts just kind of interpret it correctly, but it was always this way. And that's not really actually how the law works, because these cases do shape the law and they do change the law. And sometimes courts overturn previous decisions, in which case the law would have been different at different times. But that's not really how we look at it. So from a theoretical academic standpoint, the accused lawyer should have brought all of this stuff because he should have known that the Supreme Court would have ruled this way. But realistically, how would you do that, right? So this is going to be something that shapes things for how future lawyers will address cases. But in the case of this particular guy, he was basically supposed to follow a procedure that we didn't know existed yet. And that kind of happens in law, and I'll leave it as an exercise up to the viewer as to whether or not you think that's the way things should go. I will say that a guy who stole $18 million worth of stuff might not be the most sympathetic, but on the other hand, it was syrup that was going to be stored in a warehouse for who knows how long. So I don't know. I'm kind of torn about this one in terms of the seriousness of the offense. So, continuing on. The exercise of the court's discretion to apportion will depend on the circumstances of each case. Where the conditions giving rise to a possibility of double recovery are met, the court must apportion the value of the property between the co-accused in order to reflect the nature of a fine in lieu, which replaces the property that cannot be forfeited, nothing more and nothing less. So again, if you consider, one car, the government can take the one car. They can't take that car 6 times by taking the car from one person and then taking the value of the car from 5 more people. So that's what they're saying here is, no double dipping. But it's on the accused to show that that's a risk. However, given the approximate nature of the exercise, the court retains some flexibility in deciding how the value of the property will be apportioned between the co-accused. So that is, kind of, you might have situations where one guy is kind of a bagman and is carrying the money to another guy who's actually spending and enjoying the money. And even though he's had possession of all of it, you might say the guy who's actually spending and enjoying it is going to have to pay more of that back than the guy who, just drove it around town. That kind of seems fair. They also note that there is a bit of a burden on the Crown, because they say, while the offender bears the burden of raising apportionment and establishing its appropriateness, the Crown should, to the extent possible and where the available evidence allows, mitigate the risk of double recovery by apportioning, on its own initiative, the value of the property that is proceeds of crime between the co-accused. The Crown should discharge this duty in every case, but especially where the co-accused are tried separately, because it has an overview of the various proceedings and can limit up front the amount it seeks as a fine in lieu in each proceeding in order to ensure that the total of the fines imposed on the co-accused corresponds to the value of the property that is proceeds of crime. So this is imposing basically an ethical duty on the Crown to say, listen, you guys have a better understanding in some cases of what's going on than the court might, and you need to be aware of this and to shape your own, your own asks based on this. We will be very upset if we learn that you have gone and tried 6 people who were all involved in some case separately. So each would have a different judge who doesn't necessarily know what's happening in the other ones, and asked for the full value of the property in each case. That would be a situation, again, of the Crown, double dipping or multiple dipping there. And they say basically that the Crown should, as a positive obligation, a positive duty, say, listen, we're going to, just as a open candor to the court, because there's always a duty of candor to the court. You always have to be honest and not misleading the court. Misleading the court is a real big deal. Court gets real upset about that and say, listen, you've just convicted this guy, but we have a bunch of other dudes that we're charging. And so I know you heard that it's $10 million for this guy, but we're actually only asking for 2 because we're going to get the rest from those other guys. That's really what they're establishing here. And I think that that's a fair principle. So there's duties that apply to both the defense side and the prosecution side. So that's kind of the story of $18 million worth of stolen syrup. And the issue that takes it to the Supreme Court is kind of narrow, but it is an interesting issue. I mean, and it talks about, or at least the issues that it raises are some issues of kind of how we as a society deal with large-scale and potentially profitable crimes. Certainly, if we think about human traffickers, we don't want to see them profiting from all of this. Ultimately, the result in this case is that he's got $10 million to pay back, and they gave him, I think it was 10 years to pay it. Now, I don't know. I don't see any possibility, unless he somehow pulls off another syrup heist, that he would get $10 million together within that time. So what's going to end up happening? Well, he's going to end up serving his sentence, because he's also serving a jail sentence, so he's going to be stuck in custody. Where the heck do you get $10 million when you're sitting inside of a jail cell? And then after that, when he hasn't managed to somehow earn $10 million in jail, they're going to tack on another 6 years onto his sentence. So another result of all of this is that certain crimes, the sentencing just went way up if the government can prove all of this, because lots of drug dealers will never be able to bring to the court the total proceeds of crime, and they could end up getting real hammered. So that's a thing, I guess. Anyway, thank you for watching. I hope you found this to be interesting and educational. I'm also working on a video that is a little bit wild in terms of somebody tries to smuggle a bunch of stuff into Canada, some weapons and so forth, and then proceeds to approach his court case in the worst possible way, in ways that are hilarious and educational, because sometimes we can learn from other people's mistakes. The best way to learn is by watching somebody else fall into a well instead of doing it yourself. So, yeah. All right, so thank you for watching. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Demour. And at the $20 level, Peter Hilger, Mark Whittington, Jane Babe and Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Delso. Thank you as well to the $10 supporters who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.